important thing within the justice system is that most of the processes that lead to this detention, whatever they say, and they are different in different places, are routine and not in the formats of proceedings in which there are often human rights experts at all, or anybody who knows anything about disability. And now what I'm trying to say here is that, we might think about court cases as, these glamorous, glorious things with, cameras all around and like very well qualified lawyers making moral speeches about the law and human rights. But what often happens is that the processes that allow for institutionalization or forced treatment happen at the lowest level of the court system. They happen in day-to-day courts, and they happen in front of a judicial officer that has very little time to even look at the law, in front of a prosecutor that is coming across this issue for the first time, right, and a defense lawyer who is a legal aid lawyer paid by the state. So in these type of situations, it's not hard to see how all human rights issues get ignored, including the ones that we're speaking about. Now then it becomes important, right, that we don't think that the general judicial trainings that we do, or if we do them, should just happen with appellate level judges who are sitting on human rights cases. Because the depth of the problem is that to people who are not affected by the issues, the issues are unseen, and it happens in very banal processes within the legal system. One of the things that we have tried to do as the ICJ in working with OPDs all around the world is to try and start advocating for the judiciary itself to set up rules and guidelines. So in many systems, judicial officers have an inherent jurisdiction to decide how their own process works, and that if the government intervenes with it, they are actually impinging on the independence of judges and lawyers. And so judges, because they can do this, and very often the head of the judiciary, whether that's the Chief Justice or a Judge President, can set out practice directives or rules or anything like that. And we've been trying to focus on advocating for these type of rules to be put in place, not only for how procedural accommodations are provided, but how laws, even bad laws like these mental health laws, are implemented. Because while judges can't change the bad laws, they can use the breadth and vagueness of them in a way that is not as bad. And sometimes what you need to do is to get judges to interpret terms like interests of justice in a way that prioritizes provision of supported decision-making instead of substituted decision-making, slows down the process, allows for a person to be properly heard, properly considers whether this person in fact does need to be institutionalized. And I'm not saying that there's anybody who needs to be institutionalized, but even with a bad legal system that requires certain persons to be institutionalized, working in this area with judges and getting them to develop their own rules can be an effective way of trying to curb the problem. Another option is things like judicial bench books, which I already spoke about, to try and implement that.